Hi, Andrew Littlejohn Johnson here with Littlejohn Law, here to discuss a topic that rarely comes up until the case gets to the point where we're settling with a child, and that is minor settlements and what's required for approval of those settlements and what we must do to make sure that the child's protected. Typically in these cases, your child is injured in a car wreck or at school, or a doctor messes up, and we've worked the claim through the entire process and have agreed with the other side on an amount to settle for. And in South Carolina, the judiciary looks to the amount of money that goes to that minor child. If it is less than $2,501, rarely does the court need to approve that settlement. If it is between $2,501 and $15,000, the court normally has to approve it, as well as appoint a guardian to essentially vouch for the child and confirm that they understand where the money's going and that the settlement has been agreed on. If you get into money that goes to the child over $15,000, the court requires both an appointment of a conservator and confirmation of the settlement. So if you think about it this way, the court wants to make sure that an individual is there protecting the child's interest, conservator, and they also want to make sure that the settlement itself is proper, not only in the views of the conservator, but as the court listens to the facts of the case. Now, these hearings last maybe 10 minutes, and judges typically enjoy doing these hearings because a minor is being reimbursed for some injuries that they've incurred. Now, each case is a little different, and a lot of these minor settlements rely on my relationship with the client to get the information about the client that helps us determine the best path for the settlement proceeds to be distributed. Let's say the client has incurred, the parents, a few $1,000s in medical bills. Well, sometimes the court is able to give some of the settlement money to the parents because they've incurred those fees, those damages. In those cases, the child still gets money, but sometimes the parent would also need to be reimbursed. Also, we've had clients in the past who the child may have had some disability and required SSI, or the family has Medicaid or Medicare, or the child has some Medicaid supplement. And in these situations, it's important to take those into consideration, because the way that the child is paid, whether it's prior to turning 18 or after, may affect those government benefits. And we want to make sure that we're doing everything we can for the minor and the parents to not have essentially their life interrupted by a settlement. In these situations, we like to bring in a financial advisor who can talk with the client and answer their questions. I have never had a client that agreed to a minor settlement without knowing from me exactly what goes into it, and without knowing, if necessary, from a financial advisor, what happens. What money goes to the child immediately? What money goes to the child after they reach 18? How does the trust work? How does the annuity work? It's important for the client to understand those things. So one of the key things we do at our office, if you've watched my other videos, is make sure we communicate with the client so that they have an understanding of what's going on and what will happen later. And that's no different with these minor settlements. So if you're in the unfortunate situation where your child's been injured and you're not represented and you have some questions, feel free to reach out to me by phone or email. I know it's not a position you want to be in, but if you're in the position, getting some answers now as opposed to later could be incredibly helpful. Whatever the case may be, I look forward to hearing from you.